was the moot point before several hearings, in several hearings before the court, that what exactly is this condition? And pre-import condition, as you know, is not defined anywhere explicitly or implicitly. Only we are getting the flavor. So the question was that what is this pre-import condition, and whether the doctrine of void for vagueness would come in to play for something which is not very well defined. Now let us, before we get into the judgment, let's see that what it actually is meant when it comes to the revenue. What is revenue saying? So revenue intends to say is that if you obtain an advance authorization license, and let's say you have to export 100 tons, for exporting 100 tons, we will give you the license. We have given you the license to import 105 tons or 105 units, let's say. Now, what they say is that under this advance authorization license, you are supposed to export 100 tons. Keeping wastage and other things in mind, we allow you to import 105. If that 105 has to be imported by you, we would allow you it to be imported duty free, subject to pre-import condition. So you import 105 units, you use that 105 units, you put that to the process of manufacture, and then resultant 100 units you export. No problem. So this is plain vanilla ideal situation which must happen so as to justify pre-import condition. Now, what happens in a situation on a pragmatic basis? Business cannot run like this, that very few industries could work like that. For example, if you see jewelry industry or gold industry and silver industry, these may be able to, do this effectively because one-to-one correlation is more possible here. Now, practically, this is not possible. And hence, the question was whether doctrine of void for vagueness comes into play. Also, the dispute is for an interim period, and we'll go to that, how court has addressed that issue. Now, what happens is that in a normal business situation, this may ideally not be followed. Now, what happens? I apply for advance authorization 1. I am supposed to export same 100 tons. To export that same 100 tons, I have got the license to import 105 tons or 105 units. Now, what happens is that I have to meet the deadline for export. So I will not be able to use all my imports because I have to start the process. Maybe some process may start in advance, or partial work in progress may happen in advance. So what I do is, instead of using 105, I 50 from domestic market, and 50 from local domestic market plus 55 I have used, 105 I have used, and I have exported. So I've met the export obligation. Now, what happens in this situation is that the government is saying that you have not followed the pre-import condition to the extent of the domestic usage. Okay, let's park it till that point of time. I have in any case done my export obligation. Now, what happens with the remaining 55 units? It's my running business. So I now apply for advance authorization 2. And when I apply for advance authorization 2, let's say again I have to export 100 units, for which I have again got the authorization of 105. Now I have my stuff which is there, the raw material which is there, which is lying with me because I use some domestic. So I use that, and then I am using the new procurements also. So as far as the second advance authorization license is concerned, I have used those imported products partially from the earlier one and partially from the new procurements. Now the question which comes is that for the advance authorization license 2, whether pre-import condition has been satisfied or not, because it doesn't say, the pre-import condition doesn't say that there has to be one-to-one correlation. It says that you have to import first and then export. But will it be license wise or not? There is no clarity. And hence the question which came before the court, which before the Gujarat High Court, was that one, is it inconvenient? Two, is it practically impossible? Third, is it some situation which may lead to absurdity because one-to-one correlation may not happen? Now, imagine a situation wherein, as far as the export obligation is concerned, exporters have met the obligation. It is not the case where exporters have not met that obligation. Basis that export, in any case, the import is allowed. It is not the case where imports are not fixed as per the import output norm or the ratios fixed by the government, which is not the case. No. So now the question which comes is that whether strictly this pre-import condition has to be met, and if it is to be met, how it is to be met. Now let's come to the operative part of the decision. This is very important. If we see the Supreme Court para 75, it says what? And each line of this is very important because people have read it only in pieces. So what happens if you will read it in pieces, you will not get the full flavor of what exactly it means to do. Now let's read it line by line, only one paragraph, because that is most important for us. Now it says, for the four reasons, this court holds that the revenue has to succeed. We have no problem. So basically, it says revenue has to succeed. The impugned judgment and orders of the Gujarat High Court are hereby set aside. So it says the impugned judgment and orders of Gujarat High Court are hereby set aside. If someone will read this till here and have a pessimist approach about the judgment, you are dead. Forget it, pay everything along with interest. Now you have to read what comes later. Now it says, however, comma. What is the meaning of however? However means that whatever we have said in these two lines, there is an exception to that, which is most important for us. Winning or losing for me is not important. What is most important is that what are the repercussions? What is the impact? What is the financial impact? And that's what we would come to know, that what is there after however. It says, however, since the respondents were enjoying interim orders till the impugned judgments were delivered, the revenue is directed to permit them to claim refunds or input credit. So what has been allowed is refund or input credit, whichever applicable and or wherever customs duty was paid. It says and or. So it has 4 or 5 important elements. And there will be some youngsters also joining. The best way to read any interpretational aspect or any interpretation to interpret any line or part of the decision is to go word by word. And now let's do the post-mortem of it. So it says, however, comma. So it reverses its own situation with respect to Gujarat High Court. Now, it says, since the respondents. So first aspect is respondents. The most important aspect is that this paragraph is only for the respondents and not like our brand equity decision wherein 10,000 people got the decision. So this is applicable for the respondents. Since the respondents, so first element is respondent. Second is were enjoying interim orders. Interim orders till what time? Till the impugned judgments were delivered. Which is the impugned judgment? Gujarat High Court. So who was enjoying? The respondents were enjoying. The revenue is directed to permit them. It uses the word them. Them means who? The respondents. Which respondents? Who are before the court. To claim what? To claim refund of or input tax. So you have both the options. So my clients who are here in this presentation, please understand that you are straight away covered by this judgment. Whether others will be covered, in what way will they be covered? This is a Supreme Court decision, how presidential value it will have before the lower authorities and before other jurisdictional high court will come in a while. But as far as my clients are concerned who were there in before the Supreme Court, now what you are getting is to claim refund or input tax, whichever applicable. So you have both the options and or. Please see, the Supreme Court has used the word and oblique or wherever customs duty was paid. So Basically, if paid or if not paid and otherwise. Now, whichever applicable is for what? Is for refund or input tax credit based on our requirements. We will have to do that. And now if we move further for these respondents who were before the court, it says what? For doing so. So for doing what? For giving either the refund or the input tax credit. The respondent for availing either the refund or input tax credit, for doing so, the respondents. So the responsibility is casted on the respondents. Please note down, all the respondents who are before the Supreme Court will now have the responsibility onto them to do what? Shall approach the jurisdictional commissioner. So you have to approach your jurisdictional commissioner, and sometimes the question came, who's my jurisdictional commissioner? GST commissioner, customs commissioner, that the RI who issued that, and so on and so forth. Please write to everybody. So what you have to do is approach the jurisdictional commissioner. This is mandatory. If you do not approach the jurisdictional commissioner, you will not get the refund or ITC. And it says what? And apply with documentary evidence. So what you have to do is you have to approach jurisdictional commissioner and apply with documentary evidence within 6 weeks from the date of this judgment. So there are again 3 elements here. The respondents for claiming the benefit of refund or ITC will have to suo moto approach the jurisdictional commissioner. If you don't that, you miss the bus. Please note this. If you don't approach the jurisdictional commissioner, don't come to us later and say that, we have not got the benefit. The revenue has full right to do so. And apply with documentary evidence. What is the documentary evidence? In how many transactions you have met the pre-import condition. The pre-import, let them decide. Let jurisdictional commissioner decide whether they want one-to-one correlation for each advance authorization license, or whether they are okay with the satisfaction of the pre-import condition when in the earlier example, my imported procurements, which were not used towards the first license, is used for the second license, because again here, pre-import happens. The import is prior to the export. So I'm again reiterating, this is very important, otherwise you will miss the bus. The respondents who were before this Supreme Court, who got the benefit of this order, can get the benefit of this order by way of refund or ITC only on satisfaction of couple of chronological steps. First is approach the jurisdictional commissioner. So please write to the commissioner right away. Second, please do your working and apply with documentary evidence. Please note the word, it is broken. The 2 words which are used are documentary and evidence, both. So you have to keep your documents ready. You have to make those documents into a resultant evidence that in what cases pre-import has been satisfied, in what cases pre-import has not been satisfied. And then what it says is within 6 weeks from the date of this judgment. So within 6 weeks, some time has already passed. Within 6 weeks from the date of this judgment, please go to the jurisdictional commissioner with all documents and evidence. All documents and evidence. Please note that, otherwise you will miss it. Now, let's go to the last part of it. The claim for credit, the claim for refund / credit. So first is the responsibility on the respondents. The second part says what? The claim for refund / credit shall be examined on their merits. So now the responsibility is on them, shall be examined on their merits on a case-by-case basis. So there is no general formula. Because, and Supreme Court is 100% right, it has to be seen on a case-by-case basis. Because how can there be a general condition now? Because they have held the pre-import condition to be valid condition. But at the same time, upholding the validity, Supreme Court has given benefit to all of these respondents, but it has to be now examined on their merits on a case-by-case basis, and rightly so. Now comes the important part. for the sake of convenience. Now it is for the convenience. The revenue shall direct the appropriate procedure. So it uses the word shall. Direct the appropriate procedure to be followed conveniently through a circular in this regard. And it uses the word in this regard. So regard is for what? For granting me the refund or ITC, there has to be a circular. But before the circular, so please do not wait for 60 days if circular doesn't come. If circular doesn't come for 60 days, we may have a different challenge, which we do not want to take every time matter to the court. Because if you see the wordings here, it very clearly says that there is a responsibility on me. Please complete your responsibility, first of all. Then please wait for circular, etc. If circular, for instance, doesn't come for 60 days, please don't keep sitting. Please apply. Please provide all documents and evidence. So this is for the respondents. Now, what happens to those people who have been issued the show cause notices or whose matters are in different courts? So all the respondents before the Supreme Court are covered here. And a lot of time people ask me, Supreme Court decision will come, it will be applicable to everybody. No, it is not like that. If you are eating food, only your hunger will be satisfied. Not everybody's. It is not certain. Brand equity sort of decisions are exceptional decisions where 10,000 people get benefit because of 10 people. Here, everybody will have to fight his or her own battle in different way before DRI, before jurisdictional commissioners, by way of show cause notices and so on and so forth. Please keep in mind that revenue can tell that, this is only applicable for the respondents. Now let's come to the second aspect of it. This is a Supreme Court decision. Any jurisdictional commissioner, while assessing the show cause notice and so on and so forth, or deciding on any appeal, will have to keep this in mind. They can't shy away from this. And hence the repercussion is that ideally, all other people must also get the benefit of that circular once it comes. But it doesn't come to us as a right. We may always say that, Supreme Court decision must be followed, and our stand will always be that. But if you see the paragraph, this paragraph at least is specific for these respondents. This Supreme Court decision certainly will be applicable for others also, but you will please have to put some efforts. It will not come automatically to everybody in the country. This is my prima facie view. But yes, if the circular comes and says that, we want to extend the benefit basis this to everybody, that is most welcome. That is the pragmatic way also, because otherwise what will happen is all these other writ petitions which are in several different courts will have to quote this and get the same sort of an order. So either the jurisdictional high court gives the same sort of order basis the Supreme Court decision, or the lower jurisdictional authorities implement this in full spirit. If that happens, everybody gets the benefit. But if you see the specific wordings of the order, we can't go beyond the order. I am on record here. We can't go beyond the order. This order very categorically uses only respondents. Yes, the benefit of this order will be applicable to everybody other than respondents also in some way or the other on a case-by-case basis. So please prepare yourself. This is very important issue. The government wants to give the benefit. The judicial system wants to give the benefit. Plus, please do your paperwork. Please create documentary evidence and so on and so forth. In next 2-3 minutes, we will also go to some important aspects of this decision very quickly. Very quickly, we'll do that. First, we will go to the portion which the judge, and it's a beautiful judgment. It's very good to read. It says there is no constitutional compulsion that wills framing a new law or policies under a new legislation, particularly when an entirely different set of fiscal norms are created, overhauling the taxation structure. Concessions hitherto granted or given should necessarily be continued in the same fashion as they were in the past. Now, this aspect, whatever implications it may have for pre-import, will be the relevant paragraph which can be used for a lot of other disputes and lot of other controversies. So this is very beautifully drafted. Para 67. Please note this paragraph. This can be used by us in lot of litigation. Now, if you go to the next part of it, it says that the exporter respondent's argument that there is no rationale for differential treatment of BCD and IGST under advance authorization scheme is without merit. So the court has held that Article 14 with respect to differentiation for BCD and IGST may not be applicable. With highest respect to the decision, it's an important finding. But what has happened is, as a result, there is justification for a separate treatment on two levies. Now, if you see how they have created the reasoning, it says BCD is a customs levy at the point of import. At that stage, there is no question of credit. On the other hand, IGST is levied at multiple points and ITC gets into the stream till the point of end user. So tax cascading, non-tax cascading, and that is the reason which is being used to say that Article 14 will not kick in. Again, very important finding which can be used at various stages. And basis this, the cause and effect is that as a result, there is justification for separate treatment of two levies. Very important finding. Now let's go to paragraph 70. And it says the High Court was persuaded, this is what we argued before the Gujarat High Court, to hold that subsequent notification, because it got rescinded, the pre-import condition got rescinded from 10th of January 2019, that the subsequent notification of 2019 withdrew the pre-import condition meant that the union itself recognized its unworkable and unfeasible nature. And consequently, the condition should not be insisted upon the interim period. This court is of the opinion that the reason is faulty. Now, if the matter is now again argued before any of the jurisdictional court or before the Supreme Court, this aspect will remain very important because the Supreme Court has held this reasoning to be faulty. And why this is important is that the principles of sub silentio may come at some stage if the matter is again argued by someone basis the public interest. There was a submission with respect to public interest which has not been addressed, and that is for our advantage if the matter is heard again or if any of the petitioner wants to invoke principles of sub silentio. So I think to that aspect, we have a silver lining to argue the matter only on that aspect, again, either before the High Court or the Supreme Court, if there is a need to do so. But this is a beautifully drafted judgment with a lot of interesting findings. And then it says, in this court's opinion, what applies to refund applies equally to exemptions. So, in a way, it says that if there is any tax concession, it can be withdrawn at any time and no time limit should be insisted upon before it was withdrawn. And then it says such, and then it talks about the entire GST framework. Such a transformation cannot be painless. Such a transformation cannot be painless. Disruptions, especially in the beginning, will be felt. Yet, that in the process of unification, if a certain section of the business is inconvenienced, and that is important because we cannot use convenience to argue the matter. If a certain section of the business is inconvenienced and would have to pay taxes and conditions are imposed upon their ability to freely import, this alone cannot lead the court to conclude that such a change is unreasonable or arbitrary. So I think these are those important findings. So I think the court is of the absolute clear view that the condition is constitutional. Yes, the objective of the scheme and the benefit which must come to the Indian exporters, because these are all as per WTO guidelines, and the parliament today wants Indian exporters to get these benefits. The court has taken a very pragmatic view, a very balanced view, a very welcome move to say that refund and or credit will be allowed. Now, that leaves us to last two important aspects. What happens on interest and what happens on penalty. Well, a lot of people raise those issues, so we will address that. When the matter is of this nature and magnitude, there cannot be any question of penalty for two reasons. One of the High Court held it to be unconstitutional, and two, it is revenue neutral. So please do not worry about penalties at all. As far as interest is concerned, please understand there is no answer as of now. There is no answer as of now because even the Supreme Court says that it has to be seen on a case to case basis. So I think first thing is please prepare your documents, please create your evidence. And then as far as the legal submissions are concerned, we have complete robust submissions to say that interest must not be applicable, but that will completely depend on a case to case basis. When imports happen, what is the flow of transactions, and so on and so forth, including revenue neutrality. Now, also please understand that in this case, what the government is saying is that refund or credit is allowed. If it is allowed today, then it was also allowed before if I would have paid at that point of time. And hence the question which comes is that this becomes revenue neutral. And hence in that situation, it can be fairly argued that there must not be any interest implications on this transaction. Even if it is to be paid today, I'm getting the credit today. If it were to be paid 5 years back, I would have got the credit or refund 5 years back. The only time difference between availing the credit and utilizing the credit or availing the credit and getting the refund would be 30 to 90 days. So interest, if at all, must be applicable only for that period of 30 to 90 days. There are different case laws which are there, and it will completely depend on a case to case study of every respondent, that how interest has to be calculated, whether it is to be calculated, whether it is applicable, and there are several other justifications and grounds with respect to interest as well. But Supreme Court has not said anything that interest is payable. So please don't go ahead and pay the interest as of now. If there is litigation, please examine how they have calculated the interest, how they have imposed the interest, basis your case to case facts and documentary evidence, and basis that on different grounds, legal grounds, justification, etc., it can be justified. So that is with respect to pre-import condition. Now we will go to the order of Bombay High Court, Honorable Third Judge of Bombay High Court with respect to intermediaries. Now, first let's understand what is an intermediary and what is the problem. Intermediaries are well defined within the Act, and hence the first question for any intermediary, and there are a lot of my friends I can see here who have reached out to me earlier. The first and the foremost aspect is, please don't assume that you are an intermediary and start paying tax. Because a lot of people who have approached me have assumed, especially educational intermediaries, that you are falling within the definition. You have to basically get your agreement verified with the definition of intermediary as a first test. If the first test fails and you are out of the definition of intermediary, there is no tax. Second comes the constitutional fight. The first test is whether you fall within the definition of intermediaries. And that is again very case specific. If people will ask me whether educational intermediaries, what is the position, indenting agents, what is the position, and so on and so forth, there may not be a clear answer to me. To me, what is most important is that how is your contract drafted? What are the terms and conditions? What is the role of the Indian service provider? Basis that, if you're out of the test of intermediaries, please do not pay tax at this stage. Go for either advanced ruling or a writ petition basis, how strong your facts are. So that is the first thing. Second thing, assuming that you are an intermediary, the question which now comes is, what is the place of provision of these intermediary service providers? Now, the transaction is like this. The intermediary service provider, let's say he is in Bombay. The service receiver is outside of India, let's say Germany. And I render services to the service recipient because the service provider and service recipient definitions are very clear. I receive money in convertible foreign exchange, that is also not disputed. The question which now comes is that what is the place of provision of these intermediaries? The place of provision of these intermediaries is location of the service provider. And hence what happens is that the place of provision happens in India. And because of that, section 13(8)(b), it becomes taxable. And as a corollary, the question which comes is this technical provision correct or not? It has to pass the constitutional test. And what is that test? Whether you could have a place of provision for these intermediary services in India when the service recipient is outside of India. The services are actually rendered to him. And has lot of aspects come into play. Article 14 comes into play because you have to compare these intermediaries with lot of other intermediaries because the service recipient in lot of these services is outside of India. What also comes into play is the wordings of Article 286 because it says no state can impose tax on a supply which happens outside the state. And hence the relevance of the third judge decision comes that whether SGST can be levied by the state. We'll come to that. So now what happens is that even if there is a provision of 13(8)(b) that the place of provision is in India, as per the statutory provisions, CGST and SGST becomes applicable. But because of Article 286, no state can impose tax on something which happens outside the state. SGST cannot become applicable. IGST on this transaction cannot be made applicable because the place of provision happens in that state where the service provider is. So it's an intra-state supply. IGST is not applicable because of technical provisions. SGST cannot be applicable because of the constitutional provisions. And hence the question comes, which tax becomes applicable? And according to me, basis purely what the decision is, no tax can become applicable on these intermediaries. And hence, again, the question which comes is that whether we should at the word go challenge the constitutional validity or also basis our fact request the jurisdictional court to read down the definition of intermediary. Now, if you remember, the division bench of Bombay High Court had held, one honorable judge held that this is constitutional and the other judge held that this is unconstitutional. So what now has the third judge done to it? It is one of the most interesting cases in the history of indirect taxes in India in the new regime. Now let's see what order says, and we'll again go line by line, word by word. The order says, the provisions of section 13(8)(b) and section 8(2) of the IGST Act are legal, valid, and constitutional. If you read till here, you will get disheartened. The taxpayers may get disheartened, the revenue may be excited. Please do not read in isolation. So it reminds me of a small story where you are in a dark room and there is an elephant. You touch the ears of the elephant and you say that this looks like some curtain. You touch the trunk, you say this is rope. You touch the leg, it looks like a pillar. So if you will read things in isolation, you will be misled. You have to see holistically. Now, holistically, you see the provisions are legal, valid, and constitutional. We have no difficulty. Legal, valid, and constitutional. And then it says, comma, provided that the provisions of section 13(8)(b) and section 8(2) are confined. Please mark this word, are confined. This is the most important word, which is not only used in the operative part of the order, but also several places otherwise in the order. It says are confined. So what it does is, the order says, the Honorable Third Judge, and this is a very well thought order. I mean, beautiful order. Every single word and page of this must be read by people who would want to practice on indirect taxes. It says, are confined in their operation. So what it does is, it confines first, then confines to what? In their operation, to the provisions of the IGST Act only. So it confines 13(8)(b) in its operation to the provisions of IGST Act. And the same cannot be made applicable for levy of tax on services under the CGST and the state acts. So basically, on a lighter note, it doesn't say that this provision is bad or unconstitutional. It says yes, it's a valid provision, no problem. But it confines it. The moment 13(8)(b) is confined to the IGST Act, state cannot impose tax on these transactions. These are intrastate supplies. And hence what happens is, now what are the repercussions of this order? It says in the second paragraph, the reference as made to this court, so there was a reference to him, is accordingly answered in the above terms. The office to place the matter before the division bench. So please understand, at this stage, there cannot be any fight with this order. This order has to be synchronized now by the division bench. A lot of people ask me that if one of the judges now is not there, because one of the honorable judges is not before Bombay High Court now, he's been elevated to a different court. The matter goes to one of the judges who's there before, who's in the Bombay High Court now, and he, with whosoever judge he's sitting, honorable judge he's sitting, he will now synchronize this order and finding with that earlier order. And that earlier order is completely on two different sides, North Pole and South Pole. One says constitutional, other says unconstitutional. And third judge gives all reasoning that why this must be confined. Now, if this is confined, and even if it is constitutional, tax cannot be levied. Of course, this will go to the Supreme Court. Whatever is the final judgment now, it will go to Supreme Court, revenue will go, or the petitioners will go. But as far as we are concerned today, please note that this confines the operation. And hence, I request my intermediary service providers to get their agreements vetted at the earliest. Because if they've been paying wrong taxes, then there is a limitation period to apply for refund. Whether SGST is applicable on these transactions has to be examined. Whether they have been paying IGST needs to be examined. What will be the final decision? Can you wait till that time? Is an important aspect. We have seen in the pre-import condition that the benefit has gone only to the respondents. I am not saying for a moment that that Supreme Court decision cannot be used by other people. Of course it will be used. Every decision of Supreme Court can be used directly or indirectly by other petitioners. but the direct benefit has gone to those people who have filed the writ, who were there before the court. And hence it is important, especially where the amounts involved are huge. Please take a call, get your documents examined, and take appropriate legal remedy so that you do not miss on limitation. It must not happen that you're not doing all of this within a time bound manner. Time is of essence because delays and latches may come into play if you are going at a very later stage. Now that we have 13 minutes, some very important aspects of this decision, I think we can go through some of these. These are very nice paragraphs. And let me just see what it says is. So in the opinion, paragraph 82, in the opinion of the Honorable Judge, he says, certainly the intention of the legislature is not to tax such transactions of export of services. That is very important. Please note, all intermediary service providers. The court is of the clear opinion that the intention of the legislature is not to tax such transactions of export of services, also categorized as an intermediary services, both under the IGST Act as also under the CGST and the MGST Act. So all my friends who are here for intermediary service, please read paragraph 82. It will make your day very good. 82. Now let's go to 83. From the above discussion, what can be discerned and derived is that it is necessary to confine transactions which are clearly transactions in the course of interstate trade or commerce, and more particularly transactions of export of services. I was very honored, privileged, and I really acknowledge the patience of the Honorable Third Judge who heard me for around 10 days. 10 days. And my request to him was that, Lord, my submissions which are there must be recorded. And I am deeply and very humbled today to say that those important aspects which will come, see, winning or losing is not important. We have to play the match well. And if you play the match well and your performance speaks, then I think it makes a lot of difference, because in any case, these matters will go to Supreme Court. So recording was very important, and I requested him several times that, my Lord, my submissions must be recorded. My submissions must be recorded, because unfortunately, before the division bench, some of my submissions were not recorded. And hence, some of these paragraphs are very important. My friends, please note paragraph 82 followed by 83. It says, it is necessary. So what he does is he confines transactions which are clearly in the course of interstate trade or commerce, and it will not have implications only on intermediary service providers, but on various such services across the country. A lot of people may get the benefit of this order if it is implemented in spirit. We will see how division bench addresses that, and later possibly how Supreme Court will address this, and particularly transactions of export of services. And transactions which are in the course of intrastate trade or commerce shall remain confined to the provisions of the CGST and the MGST Act. Those words, confined, is very important. Necessarily transactions which are intrastate transactions and those which are interstate transactions are required to be compartmentalized so as to be recognized under separate regimes and without creation of any fictional incongruity in regard to the regimes. They need to be taxed in the given facts and circumstances. So please, my friends, please get your agreements vetted. Please get your transactions vetted. You may not fall within intermediaries at all. Facts and circumstances are very important. And how the Honorable Third Judge progresses, he says, it will be too harsh and not fair to the assessees to suffer any uncertainty in regard to the regimes the assessee would be taxed. Very important. Now, if you read the last line of the, if you read the first line of the order, it says it is valid, constitutional, and legal. And if you read this, if you read that in isolation, you get depressed. You get a pessimistic view about this. But if you read the whole, it's a fantastic order. And then it says The intentions of the provisions cannot be to generate disputes and litigations, but to have a smooth and definite flow under a robust taxing system. And this is all in light of the export. Now let's go further. Very important paragraph again, 84. The approach of the court would be by interpretive process to make the provisions of the respective enactments meaningful for their smooth and effective implementation. The duty of court would also be to accept the constitutionality of the provisions rather than being tilted to read the provisions to be ultra vires or unconstitutional. Very pragmatic and balanced view. It may be observed, now see how he writes that. It may be observed that it is well settled that every provision in an enactment is required to be understood and interpreted within the framework of the object. And please mark this word, my friends, intention of the legislation intends to achieve. He writes it very categorically. Intention of the legislation intends to achieve. The provisions are required to be interpreted so as to forward the intent of the legislation and the purpose sought to be achieved. And the purpose sought to be achieved. The first approach of the court would be to give effect to the legislative wisdom and make an endeavor to presume constitutionality. That's why he says it is constitutional. As noted above, this can be achieved by a process of interpretation. And then he applies interpretation and he notes that in his order, so that an attempt can be made to examine whether the provisions can be rendered meaningful. So he gives a meaningful interpretation by confining the operations of certain provisions, including 13(8)(b). Unless the provision falls foul of the well-settled norms to strike down legislation, namely lack of legislative competence, manifest arbitrariness, and or the provisions being rendered unconstitutional being contrary to the provisions of the Constitution, the court would be loath to strike down the validity of the legislative provision. So this is beautiful read. Validation oriented approach he has made applicable in para 85, and he says validation oriented approach becomes the philosophy of this of the statutory construction. Some very important aspects we are getting from this decision. Validation oriented approach has been applied, which becomes the philosophy of the statutory construction. And if another interpretation would render them unconstitutional, the court would lean in favor of the former construction. So very important again. Now we go to some portions of paragraph 86. The necessary implication of section 13 would be to the effect that section 13 is required to be held to be specifically confined only to the IGST Act. So it is for the third time he uses the word confined. So it is not a word which is loosely used in the operative part of the order. This word confined has been used thrice till now in the main order. 87 then talks about export of services. We will export that. We will skip that. Then it says towards the end, this would indirectly mean that something which could be expressly legislated to fall under the CGST or the State Act has been legislated under the IGST Act. And he clearly says that it has been in a way wrongly legislated under the IGST Act for the purposes of CGST and MGST Acts. Such intention cannot be attributed to the IGST Act, as the provisions incorporated therein are certainly of relevance and are applicability insofar as the interstate trade or commerce is concerned. So very categorically it has been held. And now what he says is, two more lines I'll read. Hence, by legal fiction, although the location of the recipient of services outside India, this is important, the transaction itself is consumed outside of India. Please note, my friends, this is very important. By legal fiction, although the location of the service recipient is outside of India, the transaction itself is consumed outside India, and that serves a purpose. By such fiction, it has been provided that for the purpose of IGST Act, the place of supply shall be the location of the supplier of intermediary services. By virtue of section 13(1), I will skip that. Now he says, on a cumulative reading of 13 and 12 of the IGST Act, as can be instantly noted, by virtue of 8(2), necessarily such supply becomes intrastate supply. So it becomes intrastate supply. Albeit that such transaction is clearly a transaction of export of services, and then he goes into that aspect. Now, how he concludes is, it is thus difficult to conceive as to why the IGST Act would take within its ambit any intrastate supply when the IGST Act itself is a legislation which concerns GST to be levied on interstate trade or commerce and not on intrastate trade or commerce. Beautifully drafted paragraph. Our interpretation has been very, very aptly put it in very right words. It has been put it to confine the applicability of 13(8)(b). Now let's skip the balance part of it because he goes to contextual this thing. One paragraph I may read. In this act, unless the context otherwise requires, the provision of 13(8)(b) cannot be applied in the context which is not attracted and or not provided, which is okay. Now we will go to paragraph 97. As there is no scope for the fiction traveling beyond the provisions of the IGST Act to the CGST and the MGST Act, as neither the Constitution, now this is very important, he gets both the elements now, neither the Constitution would permit taxing of an export of service under the said enactment, nor these legislations would accept taxing such transactions. 97 is very important, please note. The legal position which may support such conclusion can be discussed, and then he goes to several decisions which were given by us and which were argued by us for several days. And then he concludes in paragraph 103, getting all of those provisions of the Indian Constitution 14, 19, 1G, 245, 246, 246 capital A, 265, 269 capital A, and 286. 269 capital A, also please note that the word which is used is principles, not provisions, which was widely argued before him for several days. 286, again, clause 1 and clause 2 were very important, which were all argued here. And now if we go to paragraph 103, the relevant part of it, it says, in regard to such categories of persons who can also be classified as intermediaries, would be a fatal proposition. So to tax these would be a fatal proposition under 13(8)(b). It is for such reasons, in my opinion, insofar as the provisions of 13(8)(b) is concerned, the same are required to be read to confined. Again, he uses confined only to the provisions of IGST Act. And then what he says is, very importantly, when he confines it, constitutionally. He uses the word constitutionally, and that is in light of all of those articles which he mentioned just 7 lines back, and for the reasons as discussed in the foregoing paragraphs, it is not permissible for such provision to operate under the CGST Act and the State Act. So this is the key for us. Then he says that proceedings cannot be considered identical in para 104. All that is okay. So what I'm trying to say is, please read this decision. Please examine your facts. Please ensure that if you are classifying yourself within intermediary services, don't axe yourself unnecessarily if you are not covered there. And hence it is important for us to first examine whether we are getting covered there or not. So that is all from my side. We can take few questions. I would request everyone else to be muted, but the person who wants to ask any question can switch on his video and ask the question. I request all others to switch off the video And please mute yourself so that we know who the person is who's asking the question. We can start with questions of pre-import first, and then we can go to intermediaries. Any questions for pre-import condition?
Hi, I am Rajesh Shankran. Abhishek
Haji
ji,
Rajesh ji, how are you?
I'm very fine. Thank you for the this. Because we are not the respondent in with regards to the pre-import condition. So when now we can approach the jurisdictional office for making submission of our document. Is it allowed or only respondent can approach?
See, देखिए, ideally तो respondents के लिए this order is there.
Yeah.
But even if you want to go, there is no harm. Because
Okay.
see, Supreme Court order is law of the land.
Okay.
Today, I can't say, what view the jurisdictional commissioner may take.
Uh,
But yes, jurisdictional commissioner, in light of the Supreme Court order, can
okay.
address your issue. So
Okay.
what my suggestion is
Uh,
that you must go with all documentary evidence with an intent to make a payment. Please
okay.
draft your covering letter correctly so that you disclose everything correctly to them. And how
Okay.
you place the words in those covering letter is most important.
Okay.
You write that in light of.
Can you help us to make that covering letter? Whatever charge we can give you, no issue.
No, please don't worry about that. You have my mobile number and the email ID.
Yeah, yeah,
So
yeah, I
I will
have.
just, for my participants,
Hmm.
please note my mobile number 98202 41489. I will repeat the mobile number 98202
2, 4, 1.
41489. And you can email me. Everything is not related to charge, please. If there'll be something simple, I will just respond. The best way to reach out to me is to just drop a WhatsApp message and I will respond. You can also drop an email to me on abhishek@rastogichambers.com. ABHISHEK, Abhishek, @Rastogi Chambers, RASTOGICHAMBERS.com. But the best is to drop me a WhatsApp message. I will revert. For the one last time, I'm repeating my mobile number 98202 41489. So, Rajesh ji, as far as your this thing is concerned,
Yeah,
we have to be optimist about it,
yeah.
feeling that this Supreme Court order has to be made implemented on
Okay.
other jurisdictional commission, because now it's a Supreme Court order. Everybody
Yeah.
gets into the benefit of the Supreme Court order, but the
Okay.
operative part of the order very categorically says respondents. So we
Okay.
will have to convince to the tax authorities how
Yeah.
we can also justify basis our documentary evidence, documents
Oh,
and evidence, and basis
okay.
one proper letter, so
Yeah.
that if there is any inaction or no action, then
Okay.
we can also approach the appropriate authorities or legal remedies.
But that
So don't
within
worry.
6 weeks, we have to approach.
See again that 60 days is for now the respondents.
Okay.
Ideally,
Not
for
for all.
you, the limit of 60
Oh,
days is not applicable because it is for the
okay.
respondents. But
Okay.
my
Okay.
suggestion is please do not delay. My suggestion
Okay.
is within
As soon as possible.
the most appropriate time, please do that. And you
Okay.
can give them sample evidence also. So I will
Okay.
guide you
Yeah.
what can be given so that at least the process of discussion initiates and starts. Don't
Okay.
worry, we'll help you.
Okay. Thank you. Thank you for the session. I'll
Thank you,
come back to
Rajesh.
you. Yeah. Yeah.
Sure,
Thank
Hello,
you.
sir.
sir.
Sure, sir.
Hello, sir. This is Ritika. I want to
Yeah,
ask
Ritika.
what is the procedure to pay the IGST now? Do we need to
For
get our bill of
for
entry reassessed or we get the paid
for
through
pre-import
CRC?
for pre-import condition.
Yes, yes, sir.
So if you would have heard me, you will have to do the correlation of your documents and the evidence that how many imports are used and how these are used for export. At what
Right.
stage? Under each advance authorization, how you have complied and how you have used inputs of one advance authorization to offset it against the other advance authorization. So you will have to do that correlation, prepare a documentation set and evidence with respect to that, and then submit that in the most robust way before the tax authorities. So there is some arithmetic calculation, there is some permutation combination, there could be some more details which you may have to add and be guided that you do and then submit it before the authorities. And this may not be easy even for them. See, with highest respect to the revenue also, they would also want it to be followed in the best possible way. So there can be some guidance which you may get from them as well. So try to justify the meeting of pre-import condition as much as possible, and then let's see what their views thereafter.
Okay.
But please do
See,
not waste too much
my
of
question
time.
is, okay, so can we pay the same through TR6 challan, or reassessment of bill of entry is necessary? That will be guided by the revenue authorities only.
Yeah, let them tell that. See, in any
Okay.
case, if it is reassessment of bill of entry, the only advantage of that is that there is no time limitation for availing credit. But
IDC,
whatever
right.
they are suggesting to you, we can go by that. In any case, as far as I am concerned, we are getting the credit or we are getting the refund. So don't worry about that. And also, please, this aspect may not be right for me to be addressed right now because it may all be clarified in the circular which
Okay.
is to come. But please do not wait for the circular. Please initiate your action in initial 30 days or so. Don't even wait for 60 days.
Okay, sir. Okay. Thank
Sir,
you.
one
Okay.
second, Rajesh here. Sir, what
Haji sir.
she asked, because as of now, if you pay under TR6 challan, the importers cannot get the credit or input tax
Yeah.
credit because it is
Yeah.
not appearing in the system. That's why the
Yeah.
bill of entry reassessment is must. Then only we can get the credit.
So actually, so what happens is you are right. Reassessment of bill of entry, if it happens, there is also no time limit.
Yeah.
For
Okay.
other payments, there is also a time limit. But that
Yeah.
time limit, please do not worry because of the Supreme Court order.
Order. Okay.
Time
Okay.
limit now becomes irrelevant. See, that is also that, and that's a very important aspect, Rajesh, which you highlighted,
Yeah.
which I missed actually in my presentation,
Yeah.
is that how is this situation different from the situation 2 years back? Is
Back.
that now
Okay.
Supreme Court is saying that you can take credit or
Credit.
refund. So there is no
Yeah.
time limit applicable now. This
Yeah.
is per se due to the Supreme Court decision. So that's a
But
very wonderful question.
we are waiting for that circular also. The circular
Yes,
may
absolutely.
get clarity.
Absolutely. Yeah, yeah.
Thank you, sir. Thank you. Thank you.
Thank you. Thank you, Rajesh.
Good afternoon, Abhishek ji,
Yeah,
Ramesh
Ritika, you
sir.
have something else?
Thank you, sir. No other query.
Abhishek ji, Ramesh here.
Haji Ramesh ji, how are you?
Good, sir. Sir, my
Nice to
question
see
is
you
that
here.
now DRI would be again a part of it, or they will be out of the picture?
See, also, I think that's a very good question, Ramesh ji. Also, I think my readers and my followers, please note, and my clients, please note that you please also take into consideration that whether the show cause notice has been issued by DRI. And Ramesh ji has asked a beautiful question. Now, whether DRI is a relevant party or not, according
It's not audible. Networking issue.
Sir, can't hear you.
Some network issue is there.
I think Abhishek ji has we lost the connection. We'll just wait for him.
Yeah.
Yeah, we now he has joined again. I think he has lost the connection.
Am I audible now?
Yes, Abhishek ji.
I'm so sorry. I think there was some network issue. There was some problem because of which I got dropped. So my point, Rameshji, can you hear me?
Yeah. Now it's audible.
So Rameshji, my point is this, that it is the jurisdictional commissioner who's of more relevance today. But for some reason, please note, it is for you and for all other people also, that if jurisdictional commissioner has not issued the show cause notice, but if the show cause notice has been issued by DRI, please challenge that show cause notice immediately because of Canon India. Canon India Supreme Court has already held that show cause notice cannot be issued by DRI because DRI is not the proper person.
Okay. They have just sent a letter. No show cause has been issued so far.
Yeah.
Hello. Yeah, they just have sent a letter inquiring about the transactions that no show cause notice has been issued.
What I'm trying to say is
Yeah.
that you have to basically see whether show cause has been issued by DRI or not.
So far, no.
First thing. So if show cause has not been issued by DRI, you forget DRI
Okay.
and you go to your jurisdictional commissioner now.
Okay. Right, sir. I'll take your help for this and
Yeah,
I
sure.
will work with you again.
Sure.
Okay.
Abhishek ji, one question from me.
Haji.
Advance license issued before uh, 13th October 2017 and utilized after 13th October 2017. Will it be applicable for on those advance license also?
Pre-import condition?
Yeah.
Pre-import condition came only on specific date.
Yeah.
Now, see, please understand, if you have seen the advance authorization controversy, there was a controversy in which we took Narendra Plastic versus Union of India to Supreme Court to challenge that the benefit of IGST exemption must be given to advance authorization licenses with effect from 1st of July. And we won that matter in Supreme Court. So 1st of July 2017 till that date in 2017 October, whatever that date is, 17th October or something, till
13th
that time,
October.
13th
13th
October, till that time, there is no controversy. Pre-import came only later. Pre-import came only on 13th of October.
No, but actually the utilization of advance license is after 13th of October, though the date of issue was earlier.
That's exactly. That's why case to case you will have to go, but please understand. Let's say you got the license issued on 10th of July 2017. On 10th of July 2017, when you got the license issued, was there a condition of pre-import? The answer is no. Right? On that date of 10th of July, whether you could take the benefit of exemption of IGST as on that date, the answer was no under advance authorization licenses because IGST was not allowed. It was only because of the Supreme Court order in Narendra Plastic versus Union of India and several other people where we went that this change came on 13th of October.
Yeah.
So because there is a Supreme Court dismissal of revenues appeal for this issue, it becomes applicable to IGST also. Now, on that date of 10th July, assuming your license was 10th July, there was no pre-import condition. And because of the Supreme Court decision, you get the benefit. Right? So, pre-import condition is actually not applicable to those licenses which are issued prior to that date, when the pre-import condition came in. And hence, case by case analysis of everything is most important. Am I clear?
But the
Or should I repeat it again?
No. We are clear what you have told, but
Yeah.
the judicial commissioner can say that though the license was issued before the date of the 13th October, but actual
Yeah.
utilization you have done after 13th October, so
They
this
see,
pre-import condition will be utilized.
they can say anything, but that advance authorization is not subject to pre-import condition at all. And that's why case to case analysis is important. Which advance authorization licenses are issued prior to that date? Which advance authorization are issued after January of 2019? You have to segregate that. Which ones are issued in between? How you have done the pre-import condition of that, whether in that license or some other license, what correlation and records did you maintain? All that becomes relevant.
So actually the main thing is the license issued after 13th October 17 to say 19th January 2019. Whatever license were issued on those license pre-import condition was applicable. Okay. Thanks.
Amirji, can you please allow me to start my video? I think for some reason after the disconnection, it is paused. Yeah, we can go ahead. All videos are paused, I think. We can go to the next question if there is anything. Any question on intermediaries? So, my friends, with that, I
Yeah.
think we come to the end of this.
Hi,
Nah.
Abhishek. This is Pranav.
Yeah, hi Pranav. Hi Pranav.
How are you doing? Very
I'm
well,
doing.
partner. I
Yeah,
have a
yeah,
question related to intermediaries.
yeah.
So basically, unlike the pre-import condition order of the Supreme Court, where it was applicable particularly to the respondents or the petitioners,
Yeah.
in case of
Yeah.
intermediaries, I mean, how does it apply? Is it like across the board universal application so far, or again specifically only to the petitioners?
See, so far it is very difficult to say that because the matter is yet before the High Court only. But to me, if the provision is read down
Mhm.
or some specific findings are given, there is a high possibility that only the respondents will get the benefit.
Okay.
Also, what will happen is that in those cases where tax has already been paid, it may become time barred.
Mhm.
So it is best that, jurisdictional high court, in jurisdictional high court, a writ petition is filed if tax has not been paid. And if tax has been paid, then agreement may be seen and then refund may be claimed.
Okay.
At least
So
refund claim must be filed if tax is paid because otherwise it will become time barred.
right. So that is but related to refunds. But let's say going forward, right, given now the status of the order, and even though that synchronization between the division bench is still to be done, right, on a going forward basis, I mean, what would you suggest or advise, right? I mean, should tax be paid in the future, or should it just be like, not
See,
paid for now till the time? Yeah.
payment of tax will completely depend on what the nature of the transaction is.
Assuming
Whether
that,
you fall
we
within,
fall in the category of intermediary, assuming that,
so
let's say we
if you
fall in the
fall
category,
within the category of intermediaries, you have to pay
right,
tax.
even
If
after
you're
this
out
order.
of the cat, yeah, you have to pay tax because today, as we speak, it is constitutionally valid.
Mhm.
And especially if you are out of Bombay jurisdiction, this order may have only precedential value to you,
Okay.
persuasive value to the transaction outside of Bombay, because this is not unconstitutional. What they're saying is it has to be confined. It is constitutional and legal, but must be confined.
Right. Right. So logically, tax should continue to be paid because it is a Bombay High Court order. So, one is that it could be applicable only to the respondents within the jurisdiction of Bombay largely. And beyond that, it may not, it may have limited effect except for obviously having presidential value. Right?
Yeah. Unless or until you go to the writ court and get a stay on it.
Right. 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 And again, unless and until it goes to the Supreme Court and then it becomes, a widely, accepted.
And then also it depends whether the benefit will be in the way of reading it down or to strike it down.
Right. Right. And what are the chances of this getting adopted by the GST Council? And how soon, if at all?
Yeah, we can't comment on any chance and probability. Yeah, thank you so much.
All right. Thanks, Abhishek. Thank you so much.
Thanks. Yeah.
Thank you.
One more question from me, Rajesh Gupta. How to
Thanks,
claim
sir.
refund in case of IGST payment on pre-import condition? What are the procedure for claiming refund instead of
So
input
the
tax
entire
period?
procedure must come by way of this circular. And if it doesn't come by way of that circular, we will file a normal refund claim if we feel that we will not be able to utilize the credit. The way we file refund of excess tax paid, or there is also an option any other amount, we will claim in that. But I hope that this circular clarifies that how this refund will come.
And at this moment, it is advisable not to pay interest, only to pay IGST amount.
Absolutely. Absolutely. Absolutely, yes. Because Supreme
Thanks.
Court is silent on that. And according to me, this is revenue neutral.
Uh-huh. Okay.
Hello.
Hello.
Hello, Mr. Rastogi. This is Raf here.
Yeah. Hi.
My question is for the pre-import condition, can I claim the benefit on a pro rata basis of import bill of entries?
Absolutely, sir. You will have to do your analysis of the entire procurement and the benefit availed. So when you say pro rata, which means that portion of that may have qualified and would have satisfied the condition of pre-import, but a part of it may not have satisfied.
Yes, yes.
So the part of it which has satisfied pre-import goes out of it. There is an arithmetic way of computing that as well. So you please try to get your chartered accountant into play and your internal team so that you have broad framework that what is the process which you are following. Once your transactions are out, those transactions you please keep a documentary and an evidential this thing with you and submit it before the authorities to take the partial benefit. Or the remaining part you pay and take credit.
Okay. Another
The way
question
you
is
draft your covering letter and disclose it, disclosure will be most important because at no stage it must happen that you are not disclosing the transactions correctly or disclosing at least the approach correctly. If that is happening, then mostly the revenue authorities will give you the benefit, should not be a problem.
okay. Another question is that my export products are taxable and I'm exporting under LUT. Should I be still worried for the pre-import condition for the payment of IGST?
See, pre-import condition controversy is different, and if you're clearing goods under LUT, which means that you will have to check your other issues of 9610, etc.
Yes,
But you
96.
are
Yes.
yes, so that 9610 controversy is different, wherein you are charging tax or showing tax on your output and then utilizing your taxes. And if you've taken advance authorization benefit, then that restriction is there under Rule 9610. So pre-import is different. This controversy which is now being addressed is with respect to pre-import transaction.
Thank you. Thank you.
9610 is a different issue. It will completely depend how you have treated the transactions and if at all, whether you need to then take remedial action for that 9610 depending on how much is the amount involved and things like that.
Thank you.
Thank you. So I think with that we can end today's webinar and I request my participants and clients and followers to possibly drop me a WhatsApp message if there is any requirement. My mobile number is 98202-41489. Have a great weekend, my friends. Enjoy. Have a great day.
Thank you.
Abhishek.
Thank you.
Abhishek.
Thank you.
Bye.
Thank you.
Bye.
Thank you so much.
Bye. Bye.